This program is brought to you by Emory University.
Thank you, Dean Adier, for that kind introduction. Please do eat. I find that a hungry crowd is an angry crowd. And you stand between me and the door, so let's make sure you're not too angry. I'm delighted to be here. I want to thank Rachel for catching me in the parking lot, making sure I didn't get lost, and I want to thank Christian and wish him well in his upcoming political career. He's a Republican. I'm a Democrat. As far as I'm going to say about wishing him well. But I'm delighted to be here today to speak to you in connection with the Emory Law School's newest journal, the Emory Corporate Governance and Accountability Review. Now, before I really begin my remarks, there's some housekeeping things that I'm required by law to do, so let me do it. One is to give you a disclaimer that the views I express today are my own and not that of my fellow commissioners, the actual commission, or members of the staff. Second, for those scholars among you who want to know more about this, my speech will be publicly available later today. It's got some odd 66 footnotes, and the footnotes are actually much longer than the speech. So you may enjoy getting some additional information from that. But corporate governance has always been an important topic. It's even more so today, as many Americans recognize the need to develop a more robust corporate governance regime in the aftermath of the deepest financial crisis since the Great Depression. Although the recent financial crisis, aptly named the Great Recession, has many fathers, there is ample evidence that poor corporate governance contributed to the devastation that was wrought by the crisis. For example, it's been reported that senior executives at both AIG and Merrill Lynch tried to warn their respective management teams of excessive exposure to subprime mortgages, but they were rebuffed and ignored. These failures continue to remind us that good corporate governance is essential to the stability of our capital markets and our economy, as well as to the protection of investors. Now, unfortunately, the lessons of the recent past are quickly forgotten. For many, the Great Recession, which just began a few years ago in late 2007, is already in the rearview mirror. Last month, for example, the S&P 500 hit record highs, and Wall Street bonuses have reached their highest level since the 2008 crash. In addition, recent reports indicate that retail investors are beginning to return in volume to the markets. Now, all of this has taken place even though other reports suggest that there is only tepid confidence in our actual recovery. Many Americans continue to lack trust not only in the stock market, but also in financial institutions and in the U.S. economy. According to researchers at the University of Chicago, and I did look for something from memory, but this is the one I found that was more on point. According to researchers at the University of Chicago, trust in American financial system languishes at about the 24% level, with many expressing continuing concerns regarding both executive compensation and a lack of integrity among top corporate managers. Only 17% of those surveys express trust in America's largest corporations. This is a serious issue because trust is fundamental to both trade and investment. When there is a lack of trust, both Wall Street and Main Street suffer. So the question is, how can trust be restored? I believe that a key driver of greater trust is the oversight that comes from robust corporate governance. This is one reason why the work of the new Emory Review will be so important. Now, in considering corporate governance, I urge the current editorial staff and future editorial staff and their law school professor advisors to look at the issues through the prism of an investor's perspective. I firmly believe that an approach that focuses on investors is central to developing an effective corporate governance framework. It is, after all, investors that provide the capital that businesses need to grow, compete, succeed, and create jobs. They are, in a very real sense, the fuel that keeps the economy moving. Investors, of course, are not only limited to the so-called 1% you read so much about. In fact, the vast majority of investors make their living on Main Street, not Wall Street. They are school teachers and sanitation workers, factory workers, and first responders. Indeed, anyone with a mutual fund, pension fund, or a 401k plan is invested in our market. About half of all U.S. households participate, either directly or indirectly, in the stock market. And while that percentage is far less than it was during the boom years prior to the financial crisis, it remains true that millions of households invest in stock, bonds, and mutual funds in order to pay for their children's education, whether it's college or law schools, in order to save for retirement, in order to put down a down payment on their homes. These hardworking Main Street Americans are the investors that you need to keep in mind when you think about corporate governance. So a second question is, what does corporate governance mean for investors? Simply this. It means that the owners of the company are those who have paid to own the company's stock, and that management are merely their employees, albeit often well-paid employees. The separation of ownership and control is the hallmark of the modern corporation. It would be neither possible nor desirable for the many widely dispersed shareholders of any public companies to come together and manage the company's business and affairs. As a result, full-time management is essential for a company for a company to be able to operate, and any investor will tell you that talented management is extremely valuable. But even the most capable management, left unchecked, can make bad decisions, leading to undesirable results for a company and its shareholders. That is why shareholders elect a board of directors to represent their interests. Good corporate governance helps shareholders and their representatives to hire the right managers and helps to make sure that the managers remember that they ultimately work for the shareholders. Additionally, good corporate governance also helps to remind the company's directors that they work for the shareholders, not for themselves, and certainly not for management. This is not a new concept. The concept of how to make a management accountable to shareholders has been around since the modern public corporation was invented. The duties of loyalties and due care that govern the conduct of corporate directors have their roots in English common law and have been developed in the United States over a century and a half of cases by Delaware Chancery and other state courts. But it is not enough to simply state what the duties are. The exercise of these duties require the development of a corporate culture, as well as specific processes and practices that promote the fundamental principles of corporate governance. To that end, I would like to focus on three fundamental principles that should drive the establishment of an effective corporate governance regime: accountability, transparency, and engagement. And rather than discuss these principles in the abstract, I will examine them in the context of the executive compensation process. In addition, I will highlight just a few of the ways in which the S.E.C. incorporates these important principles in our rulemaking and our enforcement programs. Let's first focus on accountability. It is particularly fitting that Emory's new journal, the Emory Corporate Governance and Accountability Review, makes clear that accountability is central to effective corporate governance. Accountability means that actions have consequences. When corporate governance embodies the principles of accountability, shareholders know that performance will be measured. They know that good performance will be rewarded and poor performance will not. And most importantly, they know that misconduct will not be tolerated. One important measure of accountability involves executive compensation. Now, common sense would indicate that good corporate governance should align compensation with performance. However, recent history has to make you wonder if the principle of accountability is lacking in today's corporate world. It is well known that in the last 30 years, we have seen rapid growth in the compensation of corporate executives. Much of that growth reflects the trend toward equity-based and other incentive compensation. This form of pay was intended to align the interests of public company shareholders with those of corporate managers. The concept being very straightforward. When stock prices rise, shareholders benefit, and managers should share in the wealth through stock options, stock appreciation rights, and other awards. In essence, when companies do well, so do executives. In the boom years leading up to the financial crisis, executive pay soared. But a strange thing also was happening. Many executives have been enjoying the benefits of the pay for performance boom without necessarily delivering increased performance. In fact, the development of the golden parachute has often meant that in practice, executives have been rewarded handsomely for failure. To give just a few examples, in 2006, Viacom gave roughly $85 million in severance pay to a CEO after just 9 months in the total job. Do the math. $85 million and then they fire you after they fire you 9 months later. The former CEO of CVS received a severance package of $185 million when he left in early 2011, even though his company's net earnings had declined in the prior year. And just last week, it was reported that the former chief operating officer of Yahoo, who was fired earlier this year, received about $96 million in compensation for his 15 months on the job. That's 15, 1-5, not 5-0, for his 15 months on the job, including about $58 million in severance payments. Now, many other top executives have been shown the door with 7- and 8-figure severance payments, and there's too many for me to highlight. But when even failure can vastly increase your wealth, you don't need to worry too much about working hard to be successful, nor you need to worry too much about being held accountable. Now, one important way to enhance accountability is to make sure that shareholders are able to express their views. Now, in 2010, Congress took steps to address this concern in the context of executive compensation by requiring public companies to give shareholders a voice through so-called say-on-pay votes. Specifically, Section 951 of the Dodd-Frank Act requires public companies to conduct shareholder advisory votes to approve the compensation of executives, and to do so at least once every 3 years. In January 2011, the S.E.C. adopted final rules to implement these say-on-pay provisions. Now, although these votes are not directly binding on the company, they do nonetheless enhance accountability. Many people, when the law was going through, thought that say-on-pay votes was going to be merely a waste of time, since nothing in our history would indicate the board of directors or corporate management were going to listen to an advisory, non-binding vote by the shareholders. But a strange thing has happened. Experience has demonstrated that corporate boards pay close attention to the voter results, and that they will seek to avoid no votes greater than 25 to 30%. Moreover, early signs suggest that some companies have reacted positively to the say-on-pay regime, and that they have begun to reevaluate compensation packages when pay outstrips performance. As Senator Carl Levin has said, these provisions are intended to, and I quote, instill a culture of accountability for executive pay, close quote. An additional way to enhance accountability is making sure that the companies play by the rules. While this is true, as to many issues, it is particularly true when management is willing to break the law in order to put more bucks into their pockets. For example, in the last decade, many companies secretly backdated stock options to give executive and other employees the benefits of favorable stock price movements. Others manipulated the exercise date so that executives could profit unfairly at the expense of the corporation and shareholders. Once you know that company stocks has gone up and you backdate to the date when it was low to give somebody that exercise date, you have built in the gain. Not a good thing to do. One that the S.E.C. found to be particularly problematic, and so we pursued cases aggressively and charged dozens of public companies and their executives with frauds and reporting violations. Now, sadly, as I'm speaking to a number of future lawyers, and sadly, many of the individual defendants were those who were attorneys for these companies. They should have known better, and they clearly should have done better, and I urge you to do better and not to get into the S.E.C.'s crosshairs. We're quite aggressive in our actions, and we should be. In my opinion, the S.E.C.'s enforcement program is an absolute essential mechanism for imposing accountability on corporate affairs and on gatekeepers. Now let me address a second leg on this stool of corporate governance that I want to talk to you today, and that's this principle of transparency. Without transparency, it is difficult to have accountability. After all, shareholders can only hold corporate directors accountable if they know what is going on in the companies that they own. Now, the Commission promotes the principle of transparency in a number of ways. I'm sure that you know that we are the agency that regulates the disclosure of the 12,000 plus public companies. We do so in a variety of ways, but we do so in order to shine a light on the information that investors need to make good investment and good voting decisions. In that regard, our Rules require public disclosure of a variety of types of information, including descriptions of the company's business, its management, its board of directors, and its financial and operating data, both historical and forward-looking. It should be no surprise to you that investors have a strong interest in knowing about how the companies are doing and about the decisions that are being made. Now, this is clearly true as to matters involving executive compensation. After all, at the end of the day, it is the shareholders that pay the CEO's salary. The question is, how can an average shareholder tell if she's gotten her money's worth from the executives that are being paid? To help answer that question, over the years, the Commission has periodically amended its disclosure rules. For example, in 2006, the Commission amended the Proxy rules to help provide investors with a clearer and more complete picture of the total compensation for the chief executive, other highly paid executive officers, as well as the directors. Additionally, in 2009, in response to the financial crisis and things that we learned in the financial crisis, the Commission made further disclosure amendments. Noting an increased focus by investors on corporate accountability, the Commission adopted new disclosure requirements regarding risk management and compensation matters, including improvements to the way companies were required to report stock and option awards, disclosure regarding potential conflict of interest of the compensation consultants, and a requirement to discuss how the company's policies and practices would incentivize risk-taking. All of these disclosures enhance transparency. We're not through in all this that we're doing. Congress, in the Dodd-Frank Act, particularly almost all of Title IX, has mandated that the Commission adopt rules to address a number of the compensation-related disclosures. These include disclosures as to, first, the relationship between the executive compensation actually paid and the financial performance of the issuer. Let me read that again. Think about a public company. We are now only on the cusp of, for the first time in our 75-year history of regulated disclosure of public companies, to ask them to disclose the relation between what the executives are actually paid and how the issuer actually did. Should have been Corporate Governance 101, should have been done in 1934. Hopefully we will get around to it. I can't even promise we're going to do it because we haven't done it yet. One thing that we have done, and I want to talk about, one thing that the Dodd-Frank Act is also requiring us to do is to disclose, for the first time ever, the ratio between the compensation of the chief executive officer and the total annual compensation of one of the company's average workers. This is known as the pay ratio rule. Now, last December, the Commission took an important step to fulfill this mandate. And why is it important? As I mentioned earlier, in recent decades, the compensation of corporate executives has taken an explosive upward thrust. In fact, reports demonstrate that the compensation growth of public company CEOs has far outpaced the growth in salaries of the typical employee. For example, an April 2013 study by Bloomberg found that large public company CEOs were paid an average of 204 times the compensation of rank-and-file corporate workers. By comparison, in the 1950s, it is estimated the average CEO was paid only about 20 times the typical worker's pay, with the multiple rising to 42 to 1 in 1980 and 120 to 1 in 2000, and now to 2004 to 1. I mean, just think of it in just those short decades, from 20 to 1 to 42 to 1 to 120 to 1 to 204 to 1. One can only assume that today's executive officers are geniuses compared to the CEOs of the 50s and 60s. Now, hopefully, disclosing the pay ratios will help investors evaluate the reasonableness of a CEO's compensation in the context of a company's overall business and overall compensation scheme. It is hoped that the disclosure pay ratio will provide insights into the effectiveness of the board oversight and hopefully offset the upward bias in executive pay that seems to result from benchmarking a CEO's compensation only against the compensation of other CEOs. Now, the Commission has received an extraordinary number of comment letters regarding the pay proposal, most of which have been strongly supportive. I hope and I am optimistic that the Commission will move quickly by the end of the year to finally adopt the pay ratio rule. I also urge my fellow commissioners to act quickly to adopt the rules required and mandated for performance disclosures. Taken together with the pay ratio rule, these enhanced disclosures will foster accountability by making compensation decisions more transparent. And the disclosure should help investors make more informed investment decisions when they exercise their rights as shareholders and owners. They can see if the board of directors are taking care of management or taking care of the shareholders in a clear way. A third principle of corporate governance is engagement. Now, by this I mean that shareholders need a way to make sure that their voices are heard and that they're heard loudly and that they're heard clearly. Traditionally, the primary opportunity for shareholders to communicate with directors and management takes place only once a year at the annual meeting of shareholders. However, for most shareholders, it is simply not practicable to attend the annual meeting. They generally occur in Timbuktu when you actually live in somewhere else, and the cost and time and effort to get there is difficult. And as even in Georgia, we learned just a few years ago, probably when you were still having too much fun in high school or college, our own great public company, Home Depot, had an annual meeting in which they refused to answer any questions or take any questions from any of the shareholders who took the effort and time to get there. That strikes home. So I've been complaining about it for a bit, and I've not been the only one that's been complaining about it for a bit. Shareholders have long complained that there was a need for them to be able to have their voices heard as owners of the company. They have long complained about the difficulty in communicating with directors and management. So what can we do about it? How can companies committed to good corporate governance fill that gap? And what can security holders do to assert their rights? I will talk about three things that is taking place today. One is sort of the informal engagement process. And I'd have to commend many public companies that recently have increased their efforts to engage with shareholders and have become proactive in investor relationships. In fact, one proxy solicitation firm has characterized the current period as quote, the area of engagement, unquote. Now, it wasn't so long ago that a large public company could make national news by simply stating that they would meet regularly with investors to discuss executive pay and management practices. However, shareholder meetings and other forms of shareholder management meetings and other forms of engagement have increased dramatically in recent years. A study that came out in 2011 indicated that 87% of the issuers, 70% of the asset managers, and 60% of the pension funds and other investors surveyed reported at least one engagement over the preceding year, with most of them saying that the shareholder company contact was occurring more frequently. Let's think about that for a second. There's been big news about the enhanced engagement between shareholders and management, and investors have been so pleased that they've had the opportunity to meet once with management that they're just doing cartwheels, once with management. You would expect that the meetings to occur more frequently. Now, some people observe that the growth that we have had to the role of proxy advisory firms, which people say have allowed investors to magnify their influence. Others cite the say on pay rules. I think the say on pay rules have actually, for all the fact that they're not binding, have actually been a boon to investors. For example, here's one concrete example of how the say on pay has helped. Shortly after Johnson & Johnson received a relatively weak 57% approval rate for its say on pay proposal in 2011, the company's compensation and benefits committee chair and its presiding director, along with several executives, took a number of proactive steps to start meeting regularly with representatives of the institutional investors and with other investors as well. As an advocate for investors, I am particularly gratified by these indications of responsiveness on the part of many public companies. But let us not confuse activity with progress. According to a 2011 report, management is much more likely than investors to consider such outreach a success. It's one thing to start a dialogue, but it's quite another thing entirely to enhance communication with the shareholders and to change behavior. Investors need concrete actions to enhance accountability. Moreover, this type of engagement seems to be focused mostly on institutional investors. and in many cases only the largest of these investors. Small investors that own shares directly, the 99% of us, are typically frozen out of the process. And that's a problem because Main Street and Wall Street are rarely aligned in their views. Now, one obstacle to promoting engagement by retail investors is that individual shareholders tend to be passive investors. For example, last year retail investors voted only 30% of their public company shares, as compared to institutional investors which voted 90% of their shares. Now, I consider 30% a relatively low threshold until I think about our presidential elections and realize that 30% is pretty high. Try to get more people to vote. In today's internet age, we have a lot of tools at our disposal that should allow companies and investors to share information more frequently. And I'm thinking particularly of the electronic shareholder forms. In January of 2008, the Commission adopted rules to facilitate the use of electronic shareholder forms. And the intent was to facilitate the shareholder communication by encouraging them to talk to one another, to talk to management, to talk to the board, all by sitting in front of their computer and using the internet. Now, unfortunately, that idea may have been ahead of its time because reports suggest that only a small minority of U.S. domestic issuers take advantage of this innovation. As a result, given what appears to have been a failed attempt, I've asked my fellow commissioners and I've asked the staff to revisit those rules because it should appear relatively easy for most of us who have the internet at our disposal to be able to engage in communications with the people that we have hired to run our companies. If our current rules are not working, we need to make efforts to figure out why and to figure out what we can do to make them work. Now, lastly, another way that I want to discuss today, another way that investors seek to communicate with directors, management, and each others is by submitting shareholder proposals for consideration at the annual meeting. Now, long-standing SEC rules address when a company is required to include a shareholder proposal in its proxy statements, and I will not go into the exact details. This time of the year, there's a number of newspaper articles that have come out as to why the staff allowed a shareholder proposal, or more frequently, why the staff denied a shareholder the ability to submit a shareholder proposal to the company. So I'll leave that to the newspapers to talk to you about. But we have been quite active this year in that area. A lot of shareholder proposals that we've allowed to go through have involved executive compensation, environmental issues, majority voting for directors, and the elimination of classified boards. There's a few areas in which we've not been as shareholder friendly, dealing with some proxy access proposals, or some proposals that have recently been submitted by large institutional investors, particularly the comptroller of New York pension funds, to try to align disclosure of risk-taking with management compensation plans. I'm hoping that the staff will actually revisit that. But the shareholder proposals have been quite a boon to allow enhanced engagement, and it's been used by both sides. Last year, for example, it was reported the management of J.P. Morgan Chase & Company actively lobbied institutional investors to oppose a shareholder proposal seeking to separate the CEO and board chairman roles at the bank. Supporters of the proposals also took their arguments to shareholders. And although in this case management won out over shareholders, campaigns like these, which are becoming more and more frequent, I think, make it clear that there is a good mechanism by which shareholders and management can begin to engage with one another. Noticeably, the shareholder proposal is not an institutional investor tool. During the 2013 proxy season, individual shareholders sponsored 49% of all shareholder proposals, and that's up from 41% in 2012. Now compare that to about 16% for public pension plans in 2013, and that's down from 21% in 2012. And labor unions, which get a lot of the bad rap for misusing the shareholder proposal mechanism, seem to be flat, with about 20% both in 2012 and in 2013. Experience shows that shareholder proposals can be an effective tool to amplify the voice of individual investors in corporate governance. In fact, oftentimes the issues raised by the individual investors actually never make it to the definitive proxy statements because a shareholder proposal is a wake-up call to management management reaches out to the shareholders. They work out a backroom deal, which oftentimes isn't that bad, and as a result, the actual proposal doesn't have to be submitted for a full vote. Not necessarily the best way you want to win, but you'll take a win any way you can get it, I guess. The 2013 proxy season was also a very active season for shareholder proposals with over 750 shareholder resolutions submitted, which seems to be among the high watermarks. In the end, whatever the mechanism, shareholder proposal, shareholder forums, or in-person meetings, it is important that shareholders be able to communicate with their companies. I firmly believe that companies with corporate governance processes that enhance how they engage with their owners will be more successful than those that keep their doors shut. Now, as I come to the end of my remarks, I want to be clear about one thing, particularly about one thing about executive compensation. I am proud to live in a country where hard work, inspiration, and success can be rewarded, and rewarded handsomely. The underlying corporate governance issues regarding executive compensation is not simply about the amount of the compensation, but whether the decision-making process enables accountability through transparency and through shareholder engagement. To that end, it is important to have corporate governance practices that foster these principles and that fully and fairly explain the compensation process to shareholders. The principles of accountability, transparency, and engagement apply equally to a myriad of other corporate issuers. As owners of public companies and as the providers of the capital, shareholders have a right to know how their company is being managed, and they have a right to know the board's rationale in overseeing the company and in decisions that they're making. Now, I will conclude my remarks where I began, by thanking you for having me here today, by congratulating the entire Emory Law School community on the launch of a new journal, and by urging you to prioritize investors in your studies of corporate governance. I've always been deeply impressed by the Emory community. You've always been successful, and I expect you to be successful in this instance as well. To the students, I'm amazed you're here today since the exams start Wednesday, and I wish you good luck on your exam. Let the record show, I would not have shown up for anybody 3 days before the exam. That's just me.